Dianah, welcome.
Thank you. Thank you, Eric.
Now, is the wealth attorney a wakili?
Yes, I'm a lawyer.
What's that?
Okay.
Eh?
So my primary qualification is that I'm a lawyer. Yes, I'm an advocate of the High Court of Kenya. I'm currently serving as the head of legal and private wealth services at Anderson, Kenya. We're a global firm specialized in legal and tax matters. So yes, a wealth attorney is basically someone who has now specialized in offering private wealth service offerings. So private wealth includes tax planning. It includes estate planning. It includes wealth structuring, which is what you've talked about today, which is basically we receive your portfolio. Your portfolio is just your list of your assets, yeah, and your net liabilities, yeah, your liabilities. Then we advise on how to mitigate legal risk and tax risk. So what that means is we will look and see where you are in a higher tax bracket, and there's tax planning we can do around it and get you to a lower tax bracket. But over and above that, we'll look at what legal risk that portfolio has. So each portfolio has different types of legal risks. Sometimes it's debt. It's the way you've taken your debt. It's putting at risk other assets that are not encumbered by that debt. Sometimes it's matrimonial property disputes. These days there's a lot of very feisty divorces and matrimonial property disputes. So that becomes a risk to the portfolio. Sometimes it's succession. If you've not done your estate planning well, then the wealth cannot grow. Today I was in a meeting this morning where one of the investment managers was telling me the biggest risk they're having is as soon as the founder dies, all the wealth is withdrawn, and all of it is, if it was a fixed deposit, all of it is withdrawn and divided between people, and you cannot account for it in 2 to 3 years. So the wealth is dissipated.
Yes. There's a lot to unpack here. Very many things.
Yeah, because one of the things I want to come to is wealth and richness. What is the difference?
What is wealth?
Because some people are like, am I part of this conversation? Am I wealthy? What's the difference? We'll get to that in a bit. But as we do every day, today's quote is by Michelle Obama. She said it during the Democratic National Convention in July 25th of 2016. There was a lot of attacks going on at the time. There was a lot of insults. There was vitriol. And when she came and took the podium, she said, when they go low, we go high. Do you remember that?
Yes, I do.
Yeah. What did you take from it, and does it inform anything that you do, even in your career?
Okay. So first, let me start by saying there's a variation of that. Okay. When they go low, we pick the shovel.
Say what's up. Wow. I'm putting it under who said that. So one day we'll quote you.
When they go low.
If you're going to quote anything, you quote my friend Kageni. When they go low, we pick the shovel. Yeah. So, but I don't believe in that. I agree with that. I agree with when they go low, we go high, because the truth of the matter is, that's the one we were told when we were growing up all the time. You do not argue with a fool. They will pull you to their level and defeat you because they have experience. Wow. Yeah, they already experienced at that level, and you're not used to it. So for sure, and I think how it shows up mostly in my work would be on an ethics issue. Yeah, I do know that obviously. Yesterday I saw a meme that said, don't date a content creator, better date a doctor or those demons called lawyers. I do know that lawyers sometimes have a very negative, we have a very negative reputation. Yeah. So I think whenever we are taking ethical decisions, and at Anderson we're very clear on such matters, whenever we're taking ethical decisions in whatever we're doing, because with wealth, you're literally opening up yourself in front of me. You're being naked with your assets and how you acquired them. And I'm a lawyer, so I can tell where the loopholes are. So you need to know that you can trust me. You need to know that I will be ethical in the decisions I make. You need to know that it will be confidential between me and you, because you don't know how many times the clients come in together, a man and a woman, then later someone calls you later and says, oh, so there's another family. What are we going to do about the other assets? Yeah.
I think every lawyer has a book in them because of the things that you see.
If they weren't bound by...
If they weren't bound, that's true.
By lawyer
privilege, but by legal privilege.
Yeah.
Yes.
So just going back to the definition of wealth.
From the very basics.
From the very basics, because some people want to engage, but they feel like, and we were talking about it earlier, what I have doesn't constitute wealth, but what does?
So as I said, in my view, we could Google, but in my view, wealth is your list of assets, net of liabilities. Yeah, it's also your net worth. And wealth, I think sometimes is, yes, as I'm saying, financial, and we can account for it. But I've also met clients who had what I'd say are sentimental assets. So you'd find one thing in the family, an heirloom that is of not much financial value, but the way we are treating it in, say, the estate planning documents, or how it needs to be handed down, or how it needs to be held, is very significant for that family. Yeah, so that happens especially with Indian families. Sometimes we have some assets that are very special and have to move down a certain way. But in my view, that's the simple definition of wealth. So whatever you value.
So Kikombe again in wealth. Kikombe again, iko na sentimental value to the mother.
Iko na sentimental value nyingi.
Nyingi sana.
Ukivunja unaambiwa vunja zote. That it means something to someone. Yeah.
So wealth starts from just, anything that you own.
Yes.
Which would start from, just in a household, the furniture that you have. That's wealth.
Yeah, that is your asset. It's your wealth.
And the shamba that will be passed on to you in shags by your parents, that's wealth.
Yes.
The plot that you have bought somewhere is wealth. Your bank account with whatever little it has, that's wealth.
Yes.
So why is it important that I start planning? Hii inaisha anyway. Pesa kidogo. The people will say, hii pesa ninakula anyway. Why do I need to spend it paying a lawyer?
Right.
And to start thinking as risk and protecting and all?
Because why are you creating the wealth? Why are you waking up in the morning and showing up for this show and doing all this work when there's someone else who's sleeping and not doing anything? There's a reason you're creating this wealth. Do you have a purpose for this wealth? Did you just create it so that the lawyers can eat it in legal fees when there's a succession dispute? Did you create it so that it dissipates if, God forbid, there's a matrimonial dispute? Did you take that debt to the bank hoping to actually not be able to pay it, and then they can take everything else you had before? Yeah, so it's knowing the end from the beginning. It's knowing that I am creating this wealth deliberately for it to serve the following purposes, which the planning is why is important. When you work with investment managers, there will be people who say, let's plan for how my portfolio can generate 5 to 10 million, one holiday a year in the following places. There's someone else who wants it to, how it will cover my grandchildren's school fees. I want to ensure that all generations of Dianah coming after me, of Mureithi coming after me, get a standard of education.
I see.
Your goal has to be very clear.
Then you also talked about risks. So define risk.
Okay, so risk, that's a good question. So risk is anything. As I've said, the portfolio is basically your list of assets, net liabilities, yeah? So risk is anything that could affect that portfolio negatively, yeah? So our job as wealth attorneys, as lawyers and tax planners is to come in and define, this is the risk we're seeing, this is how to mitigate it. For instance, a tax risk. If you're, say, not, in tax risk, we have two types of risk, current tax liabilities and contingent tax liabilities. So contingent is, based on how you're structured, if an audit is done on that particular transaction or portfolio, whatever, there will be, the KRA or the Revenue Authority will be able to flag a poor, like you didn't pay your taxes, and therefore they'll issue an assessment and there will be money to be paid. So that's a contingent tax liability. So for that reason, you want to ensure that at all times, first of all, you are sitting in the best tax bracket, because tax risks are like little foxes. Sometimes you don't know that you're actually losing money because you're necessarily paying unnecessary taxes. And this is not tax avoidance, this is tax planning, which is legal. Yeah. So that's just for one risk, tax risk. But we can expound the other risks as we move along.
Right. Maybe using a case study without, of course, naming names or anything, because a lot of people will think through the money that they would spend on a wealth attorney and they're like, without thinking of how much more they could be losing through the loopholes that you've mentioned. Yeah, could you give us like an example of that?
Okay. So actually, there's one that's in the public. So consider succession disputes. Yeah. Whenever the founder has passed on, there's money, there's bonds, there's property, there's whatever assets you're considering on this portfolio. There's a succession dispute that's been triggered in court. For instance, let's assume a founder who didn't have, the oldest running succession matter I know of has been in court for 40 years. So imagine if there's a matter stuck in court for 40 years, people are arguing about who has the right to administer this estate. Is it getting administered?
No.
Are we placing these assets in the best asset portfolios? Because asset portfolios have changed, exactly. So if the money was stuck in a current account in a bank, no one has given authority for it to be moved to a better performing, asset class. It is just stuck. So succession disputes.
And attracting fees monthly. And
yes. Okay. And on top of that, hemorrhaging fees in terms of now the legal fees. The fact that lawyers are in court fighting, so that the contentious succession, I was in a place and I was telling someone, do you know that non-contentious succession can take 6 months? A lot of people think succession takes 2 years, 3 years, 40 years. But non-contentious succession, Section 71(3) of the Law Succession Act, if you're not, if there's no disputes, and if everyone is an adult, you're allowed to actually apply for confirmation of grant by reducing the 6-month period to even a month. Meaning from start to end, we can take 4 to 6 months. Yeah, in 4 to 6 months, you've saved time to do so much.
Yeah.
But beyond that, if your wealth was held in a better tool, if there was a will or there was a family trust, and therefore there's actually no reason to go to court to ask for permission to administer these assets, because you've had discussions with your beneficiaries about how will my assets be administered, what is the purpose of these assets. It's to cover, say, education, medical. If you've had those disputes, if you've had those discussions, then it means we can do that immediately. So the death of this person does not trigger an event where everything stops. There's continuity. Yeah, so that's succession disputes is one of them. Yeah.
Are those some? Oh, sorry, go ahead.
No. I was just thinking, again, there's that mindset of my wealth is too small to protect.
Okay.
Just dispel that myth for us. Because I'm thinking, my shamba in Kamulu isn't wealth.
Yeah.
My quarter acre, my vehicle, my furniture, that's not wealth.
Yeah.
What's in my savings or an MMF, that's not wealth.
Yeah. So let me start with a statistic I learned on this show. When you had the principal magistrate here, he told you 60% of the disputes in court are family related, right? One of the biggest disputes we have is matrimonial property. So that plot in Kamulu, someone says that is matrimonial property. And we want to fight and go. We actually have a matrimonial property matter that went all the way to the Supreme Court. And do you know, when you go to the Supreme Court, it's literally kutoa receipts. Because it's me, I contributed this, you contributed this.
Yes.
Let us prove what we contributed, and then what you were talking about, unpaid care work, my indirect contribution is this, my direct contribution is this. So all that time is being wasted for that plot in Kamulu. Did you acquire that plot in Kamulu only for it to be the subject of a dispute? And if you found a buyer in between that dispute, you can't. If you wanted to build in between that dispute, you can't. We have so, unfortunately, and it's a reality, as even the principal magistrate was pointing out, we have so many divorce cases ongoing. And the next step after divorce is usually division of matrimonial property. Failure to structure your wealth properly at the start will inevitably lead you there, because most couples, no one gets married hoping to get divorced. So most couples will have invested jointly, or as you're saying, there will have been unpaid, say, care work or other indirect contributions one party will have made to that acquisition, and they will be wanting to get their fair share out of it.
Right.
Yeah, I could go on and tell you that I'm now seeing positions where people come to the office and they say, we're not getting divorced only because of the property, because there will always be a wife at succession. I have refused. Yeah, maybe someone is so prominent, they don't want to drag out their stuff in public. Yeah. The other thing we're seeing, let me just say this one. So the other thing we're seeing beyond that is, in this matrimonial property disputes, is the family home. So you'll find a situation where this home, we actually acquired it together. Our children are living in this home. But now we're getting divorced, and we want to, the court is telling us if we can't agree, we have to sell it and everyone takes out their share. If my share is 50 and yours is 50, take 50-50 or 60-40. But that means if I'm left with the children, now I'm having to go move into another neighborhood where I can only afford, say, 40% of it. So who has suffered really? Your children have suffered for what? Because you failed to actually look at the law, understand what does this mean. And the fix for that is quite easy. It's if we put our family home in a family trust. And in the trust, did we say in the event of divorce, this home would be held by the trust for the benefit of the children?
Pause. Let's start this particular one as a case, okay?
Yeah.
Because you've actually given the scenario very well. So you, as a couple, as a family, live in this home. You own the home, right? Your children are growing up in this home. Then dispute comes up in the family. There's divorce. Court inawaambia, and then mkatana hiyo kitu like Solomon, cut the baby into half, kila mtu ende na half yake. That means that you're getting money. No one is getting into the master bedroom and suit and the other. You're selling the house and liquidating it. But you're saying that there's a better way of doing this.
Yes.
This particular, how do you do that?
So that's what we call wealth structuring now.
Okay.
When people are happy, let's have this conversation. So my second qualification is as a clinical psychologist. And in psychology, we say, hard conversations, easy life. Easy conversations, hard life. So when people are happy, let's have hard conversations. Let's ask each other, what would happen if we got divorced? We're not contemplating a divorce, but what would happen? And I'll tell you that for high net worth families, Sometimes even a nice lawyer like me is sent to tell people before they sign prenup agreements or whatever, this is what you're getting into. This is what would happen if you got divorced, yeah? Because for them, the stakes are high. So in that case, you have options. One, if we hold the assets in our names, yeah, and we hold them jointly, the principle of joint ownership is, in the case of death, the other one gets absolutely everything.
Yeah.
So if this person, Party A, was to die and Party B is alive, Party B gets everything. If Party B remarries, let's say Party B is the wife, remarries and has children with this other man, children of the second man now become beneficiaries of what the first husband had acquired, or even the opposite if it was the man who had died. So is that what we want in the case? Because the risk here we're assessing is death and divorce. So let's go to the second option. Let's own this asset, say through a company, a holding company. So we assess, what would it mean? Later, will we be able, can I own my 50% shareholding and your 50%? Will we be able to make decisions as a board? Because all decisions for this will have to be made through the company. The third option you have is it the most tax efficient way, especially if we don't retain it as a residential home? And then number 3 is a family trust. Now, a family trust is a tool for wealth management, but is also a succession tool. So in this case, we're saying, let's create a third entity, a third legal entity called a family trust. Let's move the family home into the family trust. And for family trust, we can use companies that are owned by the trust to own the home, yeah? So it's called a trust structure. Let's move the home there. Let's put in the trust deed that in the event of divorce, the home is held in trust for the children. Children of me and you. So we've excluded any children I have outside this wedlock, and you've excluded any children you have outside that wedlock. What that does is, if any of us were to die, the trust has not died. The trust is a legal entity. So no succession dispute. This home does not become part of your succession, even though you went and remarried. Then number 2, in the event that we have actually divorced, this is not matrimonial property. Why? Because Section 6 of the Matrimonial Property Act specifically excludes trust property as matrimonial property. So there's no matrimonial property dispute. Even though one of us tries it, the other one's lawyer will just come with something we call a preliminary objection and say, can't do this.
So what happens?
So what happens?
So we are divorcing.
Yeah.
This thing is matrimonial property. It's trust.
Yes.
For the children.
But we bought it.
Yeah. So let me finish.
So now who lives in the house?
So yeah, in the trust deed, you'll have stated that. So we call that an interest in possession. So in the trust deed, you'll have stated that whoever has primary custody of the children gets to live in that home. So I have clients who decide, this is the family resident, I'll come here 3 days, you'll come here 4 days. So it's you, the parents, who move around, especially where custody is shared. Where actual custody is vesting in one parent, that parent will leave those children there. But there is a clause within the deed that says if that parent were to remarry, they have X number of months, usually we put it like at 6 months, to move out. They can't live with their new husband there. And then in that case, the home would be rented. And all the money we're acquiring here will continue to be put in the trust fund. So for instance, we're investing other things, because now people have gotten sophisticated. We're creating, instead of us fighting about the children's, we all know my children will go to university one day. We want them to go to Harvard and Yale and wherever else we want them to go. So we're already sending money into a fund somewhere, investments, creating a university fund. So whatever other commercial rent we're getting from this home now that we've rented it, will continue to compound this. And say we've left triggers in the trust deed and said, when the youngest turns 25, divide, or let it compound to form the education fund, depending on exactly what your goals are with this wealth, which is why clarifying your goals is important. So do you see what we've avoided? If you're too contentious as parents, we will have a clause that says that you'll hand it over to a corporate trustee to run that trust. If you're cordial, if you're able to sit across each other and talk to each other, you'll remain as the trustees, because there's really not much to do. It's just to ensure that to receive accounts, to file returns, there's not much to do.
I like you answered something I was going to ask of now, what happens when the children are of age and there's disputes, but you can do it to the point where you say, if you get to a certain age, this is how you divide it, because that mitigates any sort of future possible contention. Going back a bit, so what are the 1, 2, 3 ways that people can go about protecting their wealth? They're listening right now, they have been validated. They're like, oh, kumbe, I have wealth, but I want to protect this wealth. Maybe I'm nervous to Mariam's point if it's going to cost me, but how can people protect their wealth?
Okay, so the first thing with wealth protection is look at your risks. Your risks are not my risks, yeah? So the first thing, I tell people that half the work is inventory. You see those people you're saying, Kamulu plot, I don't know Nyanyuki plot, even them, they don't know that Nyanyuki plot, the land reference number is what. They don't know where the title is. They are still processing a title somewhere, but they walk around telling everyone, I have property in Nyanyuki. All property, any asset you own.
That's true.
All property is title. don't tell me your property in Nyanyuki if you don't have a title to it. You, from a lawyer's perspective, there's so much to be done before we get there. So the first thing is inventory. Create a list of all those assets you have. Number 2, show us, create a digital record or a physical record of all the title documents to those things, including if you have, say, stocks, or you have, what are they called? You have MMF funds, or you have any other asset classes that are held in banks, bonds and everything. Tell us the account numbers, because that's number 1. Once you've done that, now the second thing is get a professional, and that's the work we do at Anderson. Get a professional to tell you what are the risks you're facing. And then legal privilege is important. Feel free, get a professional whom you feel free to disclose the things that you know, because sometimes it's debt. And we know it's coming. You know, like COVID, no one planned for COVID. No one planned for loans that were not performing, ceasing to perform because the world has shut down. Yeah. So ask yourself, what would happen if that happened? Yeah. And then have contingencies for it. Have I leveraged my home for a debt that is in the company? And if another COVID was to happen, would I lose my home? In 2019, I acted for a family that lost a home valued for 460 million, and the founder, I think, was about 70 years. So can you imagine losing your home valued for that amount at that age? At that age, you don't even have so much strength to go back to actually creating the wealth again. So face your risks. Let the experts tell you what the risks are. Then let us tell you the mitigation strategies. Because like with the one I've just told you now, we have shown you exactly how we mitigate. It's quite simple, because we're not saying that we're telling you will get divorced. We're just saying if it happened, you won't be caught up in producing receipts up to the Supreme Court.
From a corporate perspective, because we obviously a lot of the disputes, like you said, are domestic and familial in nature, but then there's also the corporate sharks. From, especially I think about it from an intellectual property angle, things that are not very easy to protect. How do you protect that kind of wealth that's intellectual in nature?
Yeah, that's an excellent question, because one thing that we're seeing now is asset classes are getting more sophisticated. Yeah, what does that mean? Just this week we've seen the CBK release. We've seen the draft virtual asset service provider bill be released. This is an one that will regulate crypto and everything. Yeah. Again, intellectual property. There is a famous, I think, on Instagram, there's a famous couple that got that fell out, and the one closed the YouTube account, the other one deleted. And you see, this was a money-making entity.
And it happens all the time. YouTube accounts are like, one day we're there, the next we're not. Or someone has put the sign saying, Mike Mondo, I don't like you, instead of now thumbnails, but go on.
Yeah, so you have to ask yourself, this is an asset class. That YouTube account is generating you money. What continuity plan do you have in all of those things happen? We fall out, the other one doesn't like, but do you have access? Sometimes it's basic things like access, which can be regulated through contracts, contractual documentation, but sometimes it's actual ownership. We have defined who owns this and how would we run with it after. So whatever it is, this class, asset classes are slowly more and more getting more and more sophisticated. So even for intellectual property, we have, beyond the normal classes we are used to, the trademarks and the patents and whatever, we have now more elaborate sort of intellectual property that's actually an asset that's generating income. So speak to your lawyer, let them tell you how we're going to regulate this. For the ones where the law has not caught up, we're still regulating using contractual documents. So that I'll write a contract between me and you and tell you we own this YouTube thing together, 50-50. If the event, this is what constitutes a dispute. If you did this, this is how we will value it. Because IFRS and accountants, people at Anderson already know how to value that. They'll value and tell you this is it, this is how much will be bought out at.
We also had Eric has a question. We all have had conversations around mediation here, negotiation, alternative forms of dispute resolution and all of that. But it seems for you, when it's wealth protection, like the automatic place to go is to court. In the event that people did not, do the protection part and they didn't come beforehand, is that always automatic, or are there other alternative forms?
No, actually we have a service offering at Anderson which we call family business mediation. So we all, let me tell you a fun fact. Every lawyer in every case, 90% of the time, they know the outcome. Because the law is written. We already know what the Law of Succession Act says. We already know what the Companies Act says, the Insolvency Act. We know. And some people, I like to tell people to know that a lot of people who go to court for two reasons. Property value, I actually have a case against you. Then the second one is nuisance value. I have no case against you, but if I make enough noise, you will come to the table and give me something. Especially with succession disputes, there's a lot of nuisance value. So even as lawyers at Anderson, we usually prefer to tell people, sit at the table, let us write it out, because unfortunately with family matters, there's also another consideration, familial relationships. Now you've stopped talking to each other and you're the parents of this child. Now what? Yeah. now what? These children will grow up how? Right. So we better find a way. And we're in court fighting over your YouTube account for 3 years. But if we negotiate a settlement within 2 months, that YouTube account can continue to be run and continue earning a passive income. You on the back end without a lot of issues. It doesn't matter that the other party is the one who's now running it. You know,
even if it's a revenue share.
Yeah, exactly. Yes, and ultimately, as he had pointed out, the court will say, split this baby into 2 and sell, buy out. So why did we wait for 6 months, for a year for the court to tell us
to get to that point?
Yeah. So I advocate for mediation, especially where families are involved, and we have trained mediators at most law firms, including at ours. We have trained mediators. We ensure that we draw up agreements that are fair. The key thing you want is to get a lawyer who's drawing up an agreement that is commercially fair, because also that's where the disputes start, where the first lawyer who originates the agreement draws it so one-sided, you're like, no, where are we starting? Yeah. But if you have good lawyers, they will draw fair, commercially viable agreements. Yeah.
One of the other risks that you talked about was the taxman.
Yeah.
That I may be paying tax for things that I shouldn't be paying tax for, just because sikufikiria.
Yeah.
Hebu sana nisaidie kufikiria.
Okay. So let me say that one of the things, so let's consider scenarios. Let's consider an asset class. So did you know that, so Finance Bill 2024, the one that now later came as the Business Amendment Laws, changed something. In family, prior to December 2024, the principal and income of a family trust was tax exempt. Do you know what that means? That means that when you are, say, acquiring one of those taxable bonds or something through the trust, you could have written to your asset manager and informed them that it's on behalf of the trust, and they would inform the CBK, and therefore it would not be taxed.
Taxed.
So that was number one, but that has since been scrapped. But also beyond that, let's look at another asset class, property. If you own residential property, and you are getting residential income for it, if I hold it in my name alone and it goes above 15 million Kenya shillings,
15 million income or
annually,
value?
The rent, the value. No, the rental income, because we tax the income. Yeah. If it goes above 15 million, then I'm taxed at a rate of 30%. But if I hold it in separate entities and it's above 15 million, so I split it and I hold 14 million here, 13 million here, 12 million here, then I'll get it taxed at 7.5%, meaning I've saved 22.5% of that amount.
So the one that I can see getting into 15 million shillings per month, per year, is maybe a block of flats. So you have a block of flats, okay, in pipeline.
Yes.
How do I separate that thing?
So now we
it's
have
one. There is one ownership document.
Yes.
How do I cut it into 3?
Well, so now we have a law that's not very new. I think came in 2020 called sectional titling. Yeah.
Yep.
So we are allowed now to create sectional titles. So we can create sectional titles for the first floor, sectional titles for the second floor, sectional titles for the third floor, and split those units. In fact, sometimes when you do estate planning for, say, people who own such assets and they want to distribute them to their beneficiaries, we can create such structures.
Okay.
But for
I thought it was as simple as block flat. First floor you pay to this account, second you pay to that.
No, it's a legal
That's
structure.
That's exactly how it went. I was like, let her continue. Then Mariam was like, you read my mind.
But go on.
So it's a legal structure, but sometimes it's not a block. If it's a block sometimes and it's just one unit, then you may be stuck. And then in that case, we want to look, but also like the 15, let me tell you another way to tax plan around, say, rental income, yeah? So for instance, with residential rental income, you're allowed to either pay under the monthly rental income scheme, which is where you do the 7.5 on the gross, or you do the annual, which is the 30%, but you're allowed to deduct your expenses. So for instance, if you constructed this block of apartments with a commercial bank loan, mortgage interest sometimes is really high. In fact, like right now is quite high. So you might actually still opt to hold it as a unit and deduct, because then the 30% of the deducted still is lower than the 7.5 of the gross.
Yeah.
So the point I'm making is, let your accountant do the math, make that decision as to whether we are holding, the question as to whether we are holding it as a unit, as to whether we are doing MRI or we are doing the corporate income tax rate, is a decision from a place of information. It's not just haphazard. Yeah, you've
MRI
done the math.
Is monthly rental income.
Yeah, MRI is, yes.
No, not.
That's why we went.
One.
Okay.
From a tax perspective still, individuals who may have like personal income that they feel is significant, and they're like, okay, no, I want to be able to get a little bit of a tax break on this, and from the obvious, apart from the deductions and the, what do they call them, the reliefs and things like that. Are there ways like that to protect your income?
So for salaried?
Yes, for salaried people. Or even if your income is not necessarily salaried in nature, but you'd still like to find ways, of course, to get a reprieve from taxes.
So when it comes to tax planning, it's like I said, first we need to see the portfolio and see the source of income, because that's what the Revenue Authority is taxing. But after that, we need to look at the legal structure. As I've told you, sometimes you might find, like previously now before 2024, holding it in a trust was exempt, but holding it in a company has a higher rate. So I'd need to specifically see what the asset class is, the income is, what type of income it's generating, then what's the legal structure.
If it's not an asset class, it's just a salary, for example.
It's a salary.
Yes.
Okay.
Yes.
So for salaries, unfortunately, for corporate bodies, there's a lot of there's a lot of what do I say? There's a lot of taxes that are due on the salary, like the pay as you earn, all the statutory deductions that are there. So there might not be much to do around it. Okay. So that for salaried people and corporate people who are relying mostly on salaries, what they want to know is, once I get the salary and then I'm investing it, am I putting it in the right structures? I'm building a business. Is the business having the control it needs, so that if I passed on, if I got divorced, I'm buying the product in Kamulu, do I have enough controls that if any of these risks came up, I am well secured?
Yeah. Right. So then from you can escape from that perspective, from the tax relief perspective.
Yeah.
But what the money goes into then can be protected.
Yes.
Can I give an example then? So mshahara imeenda imenunua plot Kamulu.
Yeah.
Okay. Then I've gone to a financial institution and taken a loan against this title of the plot in Kamulu.
Yeah.
Either to develop commercial, to apartment, to flat.
Yes.
Or to do whatever.
Yeah.
Okay. So there's a risk here, of course, of default with the financial institution, and so on and so forth. Now, help me.
Structure.
Yeah.
So the first thing, currently how a lot of our commercial lending is structured is, if say you're taking, let me assume that this person taking this, let me use a simpler example. This person, once you said they want to develop, let's assume they run the school and they're developing another JSS, part of the school, another part of the school.
It's an expansion.
Yes, it's an expansion. So that what you will find is, a lot of the times the bank will say, on top of the kind of securities, collateral, what people would call collateral that you give up to secure this loan, the first one might be something we call a personal guarantee. So a personal guarantee is basically a document where you're guaranteeing that if the company does not pay the money, I, in my personal name, will pay. You have not listed which specific assets of yours will pay. So in the event that that loan is non-performing, the first thing the bank does is issue a call on that personal guarantee, to which if any assets are in your personal name, your home, your car, your whatever, then they can come, they can be attached. Yeah.
Did you know that?
No, I didn't. No, I didn't. There's a lot.
Is it in the fine print of that loan? Or do they tell you now, so you let a personal guarantee to ongeze kwa collateral?
So you'll find that in the offer letter, there's the securities. We call them, in law, we call them the securities that have been registered. You might find that first there's a fixed charge. A fixed charge is the one where the bank registered a charge on the property.
On the property itself.
So they have the right to, if you default, to sell that property and recoup their money, right? The second one now, many times, especially if it's a company getting the loan, many times the directors will be told to sign the personal guarantees, so that the risk for such a director is what assets are in my name, and which is how my other client I told you, the one whom we came to help after the bank had gotten involved, lost their home. So the risk then is, what assets are in my name? If I have a substantial and valuable asset in my name, it should cease being in my name. Because once I perform, the loan performs and I pay it off, then it's fine, you know?
It's so interesting because you'd think going through the company, you've already circumvented that liability bit.
Yeah.
But apparently no.
Apparently not if you got additional security. So you have, a lot of people sign this document. So sometimes I've seen people and I'm like, how did you sign this document? They didn't ask anyone who actually understands the fine print. And then another question I got a question from a prospective client and said, look, I took a loan using my mom's property. And my mom's property was charged, the bank charged, but also I gave a personal guarantee. So the question I want to ask is, since the loan was taken through the company, is there any way to compel the bank to first come after me and the company as the principal borrowers and don't go for my mom's property? And those are separate contracts in law. So they can enforce what we call a power of sale by selling the property, but still come for all the guarantors as well and say we're enforcing the guarantees in case this has not been sufficient to recover the loan. And they're not bound that you must start with the borrower, then come to the guarantor. They can start with the guarantor, then come to the borrower.
Eric, you're stressed. You know, I wanted to ask about that. You know, you said 90% of the time you can anticipate the outcome. Has there ever been a curveball that's been thrown where you're like...
So I'll tell you of one of the cases that really set my career early on. And the then president of the Law Society in Kenya was in court. He told me after the court matter, I was 3 years, he told me, counsel, you've gotten more than you deserve. So what happened in that matter is, so we go to court and the bank is enforcing its power of sale. Yeah. So the bank is saying that we have a right to sell, there's a whole process when it comes to enforcing a power of sale. 90-day notice, then 45-day notice, then 7-day notice, then the proclamation of the auctioneers, then which takes about, there's a 14-day issue in the newspaper. So we are coming when we are saying the auction is like 2 days from now, and we're telling the court, please do not allow them to auction this property, we are going to resettle. So of course, commercial courts are like, please show us some good faith, because 90 days, 45 days, 14 days, 7 days, you have done nothing. Then all of a sudden, 2 days too, you want to do something. Do you know, and this is the reason they say that the law is it can carry you or kick you. What counsel on the other side had done is, they had attached the charge document, page 1, page 2, page 3, which is the pages that are usually, page 1, page 2 are usually like stamped. And then they attach the last 3 pages, like page 22, 23, 24. So the power of sale is somewhere like in page 15. So I stood up and I made the argument. The charge document before this court does not have the power they are seeking to exercise. So counsel usually would sometimes do that because you do want to print the whole document. Do you know, on that specific day, the documents before the court were not such that the court could not rely on them. So I got an interim injunction that ended up staying, because of how courts ran, ended up staying in force for almost a year. And that's what I'm telling you, that sometimes people go to court because of curveballs like that. But after that 1 year, and now that's what I was saying, that's nuisance value. That's somewhere in that thing we will get something, and that's how cases end up taking so long. It's not, okay, it was a proud moment for my boss and my boss then and my clients then, because I got them what they needed. And we got enough time to restructure the loan. Yeah, we restructured the loan and we did certain things. But what I'm saying is, that's the risk of litigation.
Right.
The moment it's out of your hands, as lawyers, we're allowed to come and argue. There's so many ways. Ask yourself, how is it that we're reading off the same document and creating 4 different arguments?
Versions and arguments. Sometimes do cases like that force you to not change the law? You know, we've seen laws come into place because of a certain incident that happened. Would that be an example of something that makes you reflect? Or is there a possibility of these laws evolving based on perhaps how things can change in future?
So my philosophy, my answer, and this is my personal opinion, my philosophy is I'm a positivist. A positivist means the letter of the law, what is written. And the law writes that if you're going to rely on a document, you bring the document in court. So the fact that you didn't bring pages, whatever, I can make that argument.
And you start by saying, I'm a positivist.
And you pull at that thread.
And unfortunately it unravels. And those are the curveballs that litigation brings up that causes sometimes they work to the benefit of one party who absolutely had no reason for it to work for them. But also sometimes they're the reason you're in court for 40 years because someone has found one weakness they can keep unraveling the thread on.
Is there a risk to gifting family members assets?
That is actually a very good question that we had not addressed, and thanks for bringing it up. So when you're planning your wealth, especially when you're doing estate planning, you have to get to the place and ask yourself, what tools are available to me? It's not I choose the tool, then fit the wealth to it, is I clarify the goal, then pick what fits that goal. So in Kenya, we have 5 types of tools when it comes primarily to estate planning. We have the will, where I write down my wishes. It becomes operative upon death, and then the assets will devolve upon confirmation of grant, upon the probate process going through court, and then the confirmation of grant is issued. So that's the first one. The second one is a family trust, which can be a living trust, meaning it's created in my lifetime. Assets move into that trust, so it's a living trust. We call it a juristic person. It's a legal person. So my death does not affect it. I was just trustee. The trustee already says how to appoint the next trustee if I die. So that's number 2. The third succession tool is something we call a form of nomination. This is specific for specific types of asset classes, like pension benefits, WIBA benefits. So for instance, you have your WIBA benefits. The form
work injury.
Work injury benefits, the ones that you have. So in that form, you've nominated who should get. And the biggest risk we see with these ones is when you started work. When I say work at Anderson, I was not married. I put my mother. Now I'm married. I have children. I never updated. I passed on now. My Anderson bosses know I have saved. I've gotten divorced and we're estranged. They know that these children are entitled, but maybe the person I named is that estranged spouse or is that mother who has since passed on. So it's so complicated. So the goal there is to always tell your employees and tell people to update their nannies either annually or after 3 years. Yeah. So that's what, or as the circumstances of their life change. You know, after your entanglements progress or or regress. And then the fourth tool. So I've talked about the fourth tool now is gifts, which you're talking about. So ask yourself, is this, and gifts are usually most appropriate for sentimental assets. So you'll find that, say, in my family, there's assets that my father has designated needs to go to the first son or to the last son or to the last born. And if that's the case, then we want to transfer them when they're both alive. Now, when it comes to gifts, what you want to do is tax plan around it and for the founder to be content with the loss of control. Because once he transfers that property to me, if I decide to build a club there, if I decide to start, pawning it off to the bank, it's mine, it's my title. And then when it comes to tax planning, there's an efficient way to gift a gift, because if it's property, if you're giving a gift from yourself to your son right now, despite the fact that because you and your son are related by blood, we can exempt capital gains tax. We produce the birth certificate, we can exempt the capital gains tax. But there's still stamp duty that your son would have to pay. So if the property is a property in Kilimani valued for 20 million, because that's within a municipality, you have to pay 4% of that. So the tax planning around it is to say, can we create a company where you and your son are shareholders initially, move the property into the company, we exempt both the capital gains tax and the stamp duty. When the property is sitting with your son, we remove you and leave your son with it now. Or we do the same also using a trust. So the key thing with gifts is tax planning and the founder being very sure about the loss of control.
That's the fourth one.
The fourth one. So the fifth one is, so I've told you about wills.
And as it trust.
Trust, gifts, forms of nomination. So the fifth one is a limited. The fifth one is a limited tool. It's called a power of attorney. So when it comes to succession risk, the risk is death or incapacity. So incapacity can arise because of, say, a mental health condition that has made you not to be of sufficient mental capacity, say dementia, Alzheimer's, or whatever. And in that case, the options are 2. If you have already granted a power of attorney to someone, you said, my daughter, my firstborn daughter, or my son and my daughter will be my powers of attorney, I've donated the powers to manage my full estate, then they'll automatically have that power. They'll take it to the bank, they'll sign your bank accounts, they'll collect your rent, they'll do everything that is in your personal name. And that's when you've created a general power of attorney. You can also create a specific power of attorney where you say, I'm only giving them rights to bank account X, and it's because I figure I will be in hospital and I need them to nanny. Even though you have a will cannot come into operation before your death. So you are alive, but you don't have mental capacity. So if you've not created a power of attorney, then your beneficiaries would have to go to court under the Mental Health Act and apply for what we call a legal guardianship order. So it's basically where they're saying our parent is no longer has mental capacity, and we want you to give us power to act as her trustees, as her legal guardians. Now that's a very grueling process. It's a very sad one because
see a lot of it in Hollywood.
Yes. Now, unfortunately, we're seeing a lot more of it here. So now what has happened now, and now it's funny because in that case, you'll have 2 children saying their mother is mentally incapacitated, 2 children saying she's not.
No, she's fine.
So, so the court is like, can you get us medical reports?
Right.
A psychiatrist will send us reports saying she is, another one will send one saying she's not. Okay. So the court will be like, we need someone neutral. Can you send to the government, whatever it comes? But it's gotten to a place where these days courts are actually insisting. Like in Milimani, most of the times we have people insisting, bring that person to court. I've been in court where someone was brought to court and he had just he was absolutely
fine,
yes, and the judge dressed down all the advocates in the matter because he was not happy. Yeah, but now the opposite also happens. Unfortunately, and these are stories that are very sad. In that particular case, later there's stories of ex-parties feeding ex-parties certain kind of medication that's making them kind of appear like they are not, so that they can get this whatever. So that whole process of legal guardianship can sometimes be very murky. And what we are advising in terms of estate planning, best estate planning practices, if someone has received a diagnosis, when they're still lucid, let them make those decisions now. Do you want to give up specific powers, even though it's just for purposes of the account that has the money that would use to pay your, your medical expenses, or do you actually want to give up all the power, or do you want to get into the gifts and start distributing what needs to be distributed, but when they're still lucid? Because after they're not lucid now, if you don't have anything in place, you'll have to go to court.
We're just about to run out of time, but I saw someone on YouTube saying sectional title for the show is tax avoidance. That's Ethan's empire. But I want to, just before we let you go, for people to have the difference between tax avoidance, tax evasion, tax planning, those three things.
So let me first say it this way. Tax avoidance is, and the TPA, what is it called? The TPA is the Tax Procedures Act, It's quite clear. If you take very adverse measures to not pay the taxes that you're supposed to pay, that's tax avoidance, and the commissioner can still assess you for those taxes, That's number one.
Is it an illegality?
Yeah, that's illegal. Yeah, that's why the commissioner can still come. The commissioner of revenue can still come and assess you for it. Tax planning, as I've said, is taking advantage of legal rules, like that I've told you about structuring for family-owned businesses. The law, through a gazette notice, has created that provision. So it's meant for people to use it, With regards to his comment as to whether this is tax avoidance, I don't think so. Why? But as I've said, different lawyers have different opinions. Why? I do have a client who owns a mall, and his succession plan is everyone's going to own one floor of this mall. So when he tells us to create sectional titles for each floor, the floor, it has 5 floors, and
for succession purposes.
And it's going to you as a child, and her and her and her. So have we really done just to avoid the taxes? Because this is the key asset he has, and he wants he wants it to be owned by everyone. So we are finding a way to actually ensure that everyone gets a chunk of the cake, a piece of the cake. So I don't necessarily agree with him. Of course, the Revenue Authority would also have the opportunity to interrogate the transaction and see whether you avoided taxes.
Okay.
Thank you so much.
That was very informative.
Indeed.
Indeed, it was. Dianah, thank you very much. In fact, even people are saying very informative. Kennedy Nyaminda says that. Anthony Murimi says, great. Smallest ever is still at that point of what is wealth, what is riches. She says, for me, wealth isn't about riches, but peace of mind. I strive for a balance. Amassing vast wealth only to be bogged down by legal issues, security concerns is daunting. It's too much.
It is.
It's too much. Thank you very much, Dianah, for joining us. Dianah Mureithi is a wealth attorney. That's what she is. She's an advocate of the High Court of Kenya. She's also a trained psychologist, and she uses all those things to bring into the fore of helping people just to manage your assets properly, to mitigate all the risks. Asante sana for joining us. We're going to the girls.
We're going to your world. I don't know that we have the topic they're discussing today, but
I saw it.
Did you see it?
Yeah, today is the 9th.
Today is the 9th, yes.
It's the 9th.
So I'm the one who missed it somewhere.
His lifestyle and his health. How does the way a man live affect his health and well-being? I don't know, man. I'd like to know this.
Yeah, you have.
Felix Kithenji, who's a men advocate and mental health coach, will be here. Professor Peter Mungai, who's a urologist. Where? And Dr. Wanjiru Karemi, consultant urologist as well. That is coming up.
That's coming up with Mikali and Winnie. Thank you so much. Today was a really just a bit of a shifting conversation and program all around. Thank you guys so much for staying with Fixing the Nation on NTV, on Nation FM, across our social media. The conversation still continues, right? And everything we've talked about, if you missed it, you'll catch it online a little bit later on. But for now, from me, Janet Bogwa, Mariam Bishar, Eric Latif, thank you so much. Have an incredible day. We'll see you back here tomorrow, 6 a.m.